5, 4, 3, 2, 1. The High Court also pointed out that the petitioners could not prove that there was any material irregularity or fraud in conducting the sale. The High Court noted that a perusal of the order sheet maintained by the executing court shows that the appellant filed an application under Order 21, Rule 90 CPC, and in the said application, the court adjourned the case for filing objections to the said IA. On 30/9/1995, the respondent filed objection to the IA. Thereafter, the matter has adjourned for evidence. On 20/10/1995, at the request of the advocate for the appellant, the case was adjourned for evidence and hearing. On 31/10/1995, the advocate appearing for the appellant submitted that his objections may be taken as his arguments. Accordingly, the court passed the final order on the application filed under Order 21, Rule 90 CPC. The above said facts clearly disclose that though opportunity was given to the appellant to give evidence to prove their fraud or irregularity, he has not availed of that opportunity and proved the fraud or irregularity as alleged in his application. Therefore, there is no reason to set aside the sale on the ground of any irregularity or fraud in publishing or conducting the sale. On 8/4/1996, the court orally suggested to the counsel for the appellant to pay the amount due under the decree along with the solatium at 15% paid by the auction purchaser, for which the auction purchaser has no objection to set aside the sale provided he has been paid the amount as suggested by the court. For this suggestion, the counsel for the appellant agreed to pay the amount as suggested provided some time is given to him. Accordingly, the case was adjourned to 18/4/1996 with an understanding that the appellant shall pay the amount with solatium. On 16/4/1996, the advocate submitted that on amount of the communication gap between him and his client, he was not in a position to say whether his client is willing to deposit the amount as directed by the court. This submission, in my view, is only to avoid payment and drag on the proceedings. Though the indulgence was shown by this court to the appellant, he has not made use of the said situation to save the property. Hence, I find no reasons to interfere with the order passed by the trial court. Accordingly, the appeal is dismissed with costs of ₹1,000. A reading thereof would clearly indicate that opportunity was given to the petitioner to establish whether the sale was vitiated by any material irregularity or fraud in publishing or conducting the proclamation of sale by the decree holder. Except repeating the averment and raising a contention in the written arguments, no evidence was adduced to prove them. Under those circumstances, the material conditions required under Order 21, Rule 90 SPC are not proved. It is contended for the petitioners that they are prepared to pay the amount if an opportunity is given to them. The High Court, in fact, gave the opportunity to pay the amount with interest at the rate of 15% on the sale amount, but the petitioners have not availed of the opportunity. The High Court has observed that the petitioners intended to prolong the finalization of the sale. We think that the observation made by the High Court is justified on the facts. We do not think that it is a case warranting interference by further extension of time. The special leave petition is accordingly dismissed. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.